Hello everyone, welcome back to the channel. So today we're going to be doing a CPP session where we'll be going through the ethics and law content that may appear in your exams. So this is some of the things that we will be covering today. So the first thing to cover is capacity. Capacity is the ability of a patient to make a medical decision. And we need to remember the Mental Capacity Act 2005 in order to know the principles of capacity. So there are 5 principles of capacity. A patient must always be assumed to have capacity unless they've otherwise been proven to lack capacity. And in order for a patient to have capacity, they must be able to do the following, which is understand, retain, weigh up, and communicate back a decision. If they can do all 4 of these things, then they are deemed to have capacity unless proven otherwise. Some things that may cause a patient to lose capacity may be things like progressive disease and disorders like Alzheimer's, where over a long period of time as the disease progresses, you lose memory impairment and therefore capacity. Number 2, you cannot deem a person to have capacity unless all practical steps to aid capacity have failed. So, for instance, if a patient cannot speak English, that doesn't necessarily mean they don't have capacity. You need to do all the practical steps to help them to demonstrate that capacity. For example, providing a language translator if they're deaf, providing hearing aids, or someone who can do sign language. Other examples could be providing a written information if they can't all hear, and so all of the practical steps can be providing braille for patients who can't see. All of these steps must be done in order to aid capacity before you can deem a person to not have capacity. And the third is a patient who does have capacity is able to make a decision even if it is an unwise decision. So a patient can decide to not go through with a treatment that would be very wise, and if they have capacity and they make that decision that they don't want to have that treatment, they're perfectly in the right position to do so if they've got capacity. But if a patient doesn't have capacity, then any acts and decisions should be made by another party in their best interest. And we'll get into who can make those decisions in the patient's best interest in a bit. And 5, for a patient without capacity, acts done or decisions made should be the least restrictive to their rights and freedoms of action. So you want to be maintaining their basic human rights and freedom of action. So as I said, the criteria for assessing capacity: a patient must be able to understand, retain, weigh up, and communicate back a decision. A lacking capacity does not mean that they will need another third person, such as a family member or a court. We'll get into that, will be making decisions on their behalf, but that does not exclude the individual from participating in the decision-making process, and they should always, as an act of courtesy and etiquette, be informed of what's going to be happening with them in terms of treatment, even if they lack capacity to make decisions on behalf of themselves in regards to treatment. And for consent, another thing you should remember is consent. So for a patient's consent towards a treatment or a drug to be valid, it must be fully informed. So they must know about the important risk factors, any common side effects, what will happen before, during, and after the procedure, what will happen in the recovery time. It must be voluntary, so they can't be coerced by another person to make a decision, and they must have capacity. And the 4 above is the things we look for to assess whether a patient has capacity. So have a go at this SBA. So this is the answer for advanced care planning. A patient with capacity can use an advanced decision to refuse treatment for the purpose of rejecting water. So no, a patient cannot use an advanced decision to refuse anything that's life-sustaining, such as basic food and water and nutrition. A lasting power of attorney must be appointed in writing by two consultants to make the best interest for a patient once they have lost capacity. There's two things wrong here. So the correct would be the lasting power of attorney. It must be appointed by the patient themselves, and they must appoint it before they've lost capacity. If after they've lost capacity, the thing that comes in at that stage is the Court of Protection can then elect a deputy of court, but we'll get into that. And C, a deputy of court is appointed by the Court of Protection in order to make life-sustaining decisions for a patient who has lost capacity. No, they do not appoint the deputy of court to make life-sustaining decisions. It's more to make decisions of in the patient's best interest after they've lost capacity. And the Court of Protection comes in after a patient has lost capacity. They can appoint someone, or usually a family member or relative, to make decisions on their behalf in terms of their best interest, but it's not usually on life-sustaining decisions. It's more treatment-based decisions. And an independent mental capacity advocate can overrule a medical team's decision on significant medical interventions. So this is false. The final best interest decision usually lies with the medical team and not the independent mental capacity advocate, who usually comes in if the patient doesn't have any friends or family or relatives who can make decisions on their best interest, would bring in the independent mental capacity advocate. And E, this is the correct answer, an advance statement. Do not confuse this with the advanced decision to refuse treatment. The advance statement is not a legally binding document. It's merely a document or a statement that is given in advance to suggest what some of the patient's preferences might be, and it is advisable for the patient, for the doctors to take it into account. However, if they decide with reasonable and rational judgment that something else may be appropriate, they can go through with it. It's not a legally binding document. However, the advanced decision to refuse treatment, that is legally binding, especially if it's been written down. If a patient makes a decision and puts in the legal documents in a written down format that they would like in advance to refuse a particular treatment, it is legally binding, and as doctors we are obligated to respect that. So advanced care planning. Advanced decisions to refuse treatment can only be done by an adult over 18. They are legally binding if written down. You cannot refuse basic life support, such as basic comfort, life-sustaining treatment such as food, water, nutrition, analgesia, and basic hygiene. And you cannot demand a treatment, but you can put in a advanced decision beforehand to refuse a treatment or to not go through with it. Patients can refuse also medical procedures such as NG tubes and peg insertion, because these are not deemed as life, even though they are life-sustaining. It's more of a medical procedure which carries its own risks, benefits, and discomfort, so the patient does have the right to refuse these in advance. So then we have what to do before a patient loses mental capacity, after a patient loses capacity, and if a patient doesn't have any family or relatives who can then be elected to make decisions on the patient's behalf. So before a patient loses mental capacity, they can appoint someone called a lasting power of attorney. So this is usually when they have capacity, they can put in a document to appoint another adult decision maker to make decisions on their behalf should they lose capacity. And the lasting power of attorney kicks in once the patient has lost capacity, and then the LPA can then take over and start making decisions which have to be in the patient's best interest. Now, the lasting power of attorney can overrule the advanced decision to refuse treatment, but in the document, the patient must have written down to the extent of which they can do this, so whether the LPA can overrule the advanced decision to refuse treatment. And any decisions must be done in the patient's best interest. Now, the court of protection, this is when happens after a patient loses capacity. So they're basically a court in England and Wales who make decisions about financial and welfare matters for people who can't make decisions on their own because they've lost capacity and they haven't had an LPA put in place before they lost capacity. So what the court of protection will do is they'll appoint a deputy of court who is usually a relative or a family member, and they can make decisions on the best interest of the patient once the patient has lost capacity. They cannot, however, make decisions with everything that we've done throughout on life-sustaining treatments that includes analgesia, basic hygiene, nutrition, food, and water. So the main difference is a lasting power of attorney is appointed by the patient themselves before they lose capacity to make decisions about their best interest once they've lost capacity. So it's more prospective. And the deputy of court is appointed by the court of protection after a patient has lost capacity. It's usually a relative or a family member to make decisions about what's in their best interest afterwards. So it's more of a prospective a way of ensuring that the patient's decisions are made upon the patient's best interest. Now, what happens if a patient has no family or friends who cannot make decisions on their behalf? Then in those cases, an independent mental capacity advocate can step in, and they can help to make decisions and contribute towards significant medical decisions. However, ultimately, they usually do this by speaking to relevant parties, accessing medical records, and contributing to the decisions that may be in the patient's best interest. And however, ultimately, the medical team is the one that has the decision of the patient's best interest in incidences where they may not have any contacts who can advocate for them. And the other thing to note is that an advanced statement, not to be confused with an advanced decision to refuse treatment, the advanced statement is more of a document that is not legally binding, and so it can be overruled by an LPA if they're given specific powers to indicate what the patient's preferred treatment would have been if they were to be able to make that decision. And a newer advanced statement usually overrules an older one, so newer statements are given more weight to older ones. So the most recent one is the one that the team will usually go with. And then the final thing to note is the 6 principles of best interest decisions. So we say quite a lot we want to be making decisions in the patient's best interest, but what does that actually mean? It means the 7 things. So first, you must involve the person in the decision making where possible. 2, you need to consider all of their relevant circumstances, so their past medical history, their social circumstances, language to see what could be in their best interest. 3, you must find out about the patient's past or present wishes and feelings, as it can indicate what their most likely opinions would have been if they were to be making those decisions themselves. 4, find out about the patient's beliefs and values. For example, if the patient is, that they're a Jehovah's Witness, then a decision in their best interest could indicate that they potentially wouldn't want a blood transfusion if they were to need one after a traumatic injury. 5, consider any advanced statements, because this can give you clues of what their opinions and beliefs and wishes and wants are. 6, consult significant others, family, friends, careers, and IMCAs, so independent mental capacity advocates who may have looked through their records, who may have an idea of the patient and their values. And 7, choose the least restrictive option. So the option that is the least restrictive to their human rights and freedom of action. Thank you so much. I hope that made everything clear. Please feel free to like, comment, and subscribe, and also comment if there's anything that you would like clarifying or would like to be explained a bit more. Thank you for watching.